Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to episode 88 of Fire Away. Today, I'm very excited to be continuing the conversation about artificial intelligence, which we could probably continue for another 7 or 8 or 9 episodes. But today, we're going to talk a bit about AI in the workplace, some of the fears, some of the concerns, and how to address them. I'm very excited to be joined by 2 very interesting guests with different backgrounds. So first of all, at least in the order of how I have them listed, we have Kent Peel. Kent is a law professor at Seneca College and a self-described, at least on LinkedIn, Gen AI thought leader and a dedicated college law prof exploring cutting-edge technology for legal education and practice. So Kent is one of the smart ones who went to law school but is not practicing law anymore. My second guest is Yashar Daf, who is the co-founder and CEO of Kolabrya AI, which is a really neat AI tool for lawyers and those of us in the legal industry. And Yashar, I love your quote on LinkedIn that you're deeply passionate about leveraging productivity-enhancing technologies to streamline workflows and drive efficiency in the legal industry. And as someone whose firm is really all about using tech and being efficient, I love it, which is how we initially connected. So thank you both for joining us. Welcome to Fire Away.
Thank you.
Thank you.
So we'll start off with the easy question, which is to tell me a bit about your story and why you like to talk about generative AI. Yashar, I'll start with you.
Sure. Thanks for having me in this podcast. My background is cybersecurity and technology, and it's interesting because I used to do a lot of cybersecurity and cybercrime investigation dealing with large documents. And so this was around the time that OpenAI was coming, and I thought to myself, is there a better way to do this and sort of outsource some of these secretarial tasks and improve the efficiency to AI? And that was around the time 2 years ago where I started sort of co-founding the firm and start looking into the AI technology to see if we could gain efficiency and productivity from overall AI and technology.
Very cool. Kent, what about you?
Hi again. Thank you as well for letting us rant on about this. My name's Kent. I'm maybe Seneca up there. So I feel obliged to clear my throat a little bit here and say the Gen AI thought leader was a title given to me, I have to point out very quickly, by Seneca. I didn't choose it. And so I've been teaching at Seneca for about 20 years in the legal programs. And technology, of course, has been, we're a bit behind because of just just the speed at which law tech has gone ahead. But I've been teaching it for a little while. We, as an institution, are very concerned about AI. And so they created this position to try and infuse generative AI, particularly throughout the college. So right now, my mandate is to learn from people like Yashar, like you, and try and get AI goodness into pretty much everything we do. Of course, I have a soft spot in particular for law tech.
Very cool. I have to admit, I was hoping to learn from you. So I guess we'll see which one of us actually ends up learning something today. But again, thank you both for joining me. So I wanted to start really just by talking about where we are, because we've been talking about AI for as long as I can remember. But now, the term AI, currently we're referring to generative AI, which we'll probably get more into as we talk. But I read a great article recently which talked about how it's gone from a party trick to a useful tool. And that's what I'm seeing as well, that, it is being used, the use is incredibly widespread. And some people are really heavily into it. Some are playing with it a bit. Some are really just experimenting with, quick little questions on ChatGPT. But the point is, I think it is at that point now where it is something that we need to take seriously in terms of what it can be used for and how it can be used in the workplace. So, but that's my take. So I was curious to see what you guys think.
I can take.
Rats.
I knew we'd have one of those awkward moments at some
Yeah,
point.
sorry about that.
Yeah, no worries. Whoever talks first gets to speak.
I'll take a stab at it. So I think from my perspective, if you look at the life cycle of any disruptive technology, or actually any technology, it goes through stages. It's sort of like creating a team where you go through, the norming, forming, storming stage in a team building exercise. The same applies into technology. And you start with innovation, early markets, crossing the chasm, as they call it, and then it goes through maturity. At the end of the day, after years or maybe decades, it sort of declines, and then we see a new technology coming to light. I think where we are with AI today is depending on what lens you look at. If you look at the lens from a B2B, those are really businesses and enterprises. I think that they're still in sort of refinement, credibility assessment of the technology overall. If you look at it from a consumer perspective, I want to create a cool image on one of my school projects, or I want to sort of quickly summarize something, I want to write a letter, etc. Those are sort of the consumer specific. And if you look at that lens, I'd say we're probably in the mainstream adoption of Gen AI today.
I would agree with that entirely. It was very well expressed. I thought that this, and I like what Stuart you said at the beginning. For right now, for a lot of people, perhaps even too many people, it is still a parlor trick. It's still just a party trick. And I couldn't agree more with the comment that's about building that trust and confidence. And so that's what we're seeing. We're seeing everyone kind of nibbling in there. It handled the email. Now I can move on to like contract review or something far more sophisticated and linguistic. I think the big challenge for a bunch of people, I won't project my faults onto anyone listening or anyone in this room, but I will say it's the fact that you probably aren't using it nearly as often as you could and be effective with it, which is a big piece. It's the effectiveness with it that a lot of people, I can write my email. As Yashar just said, of course you can write the email. The question though is, can you do it faster, better than AI can? And I think that's the big thing, that's what's so shocking about it, is it can often do a pretty darn good job right out of the gate. And trusting it to do more and more of these tasks and letting go, that's, I think, the challenge ahead of us. So there's, I think, a human bottleneck in the process. That's going to change, though, very fast.
Yeah, I think that makes sense. And you hit on a really important term there, which is trust. Because I think a lot of people don't trust it. And, if lawyers, as I think we all probably know in this room, tend to be pretty conservative. And I think I'm in the minority when it comes to adopting technology. But for the most part, and we just saw this. I don't know if you guys saw this, but it was within the last week or so that Justice Myers from the Ontario courts, who tends to be fairly outspoken, really lambasted a lawyer for submitting a brief that included case law that was just hallucinated by, it hasn't been proven yet, but it looks like it was hallucinated by ChatGPT. And it looks like this lawyer didn't do what you should do, which is review it, make sure the cases are real cases, that the quotes are real quotes, etc. But when you hear stories about like this, which make their way around the legal profession extremely quickly, it just adds to the distrust. So I guess I'm wondering what you guys are seeing, or how you get past that, how you get past that fear that people seem to have that, I can use this to kind of do some simple work for me, but I can't trust it to do anything more complex.
I think it's two, at least how I think about it, is that there are two angles that we could take a look at this problem. One is the technology itself, where it is at its current trajectory in terms of its refinement, where it currently sits at. Like you talked about hallucinated citation of cases, that is a real problem. It's a big problem. It will impact people's life. But that's where current technology limitations are. At the end of the day, AI works on probabilistic algorithms. And I always say that AI always prioritizes sentence coherence. So it might as well, in many cases, it will hallucinate if it doesn't find the right information it's in training set. So that's the technology lens and the capability and limitations of where AI is today. I think the other lens is the user behavior and, the expectations of people from the technology. I think because of the huge hype that we saw a few years ago when ChatGPT was launched, I think the expectations was this is going to do such an amazing job. It's not going to hallucinate. It's not going to make mistakes. So I think that's the expectation in a lot of people's minds today when they want to use it. And so not recognizing the technology limitation could influence how we use or not use, which then, leads into, could we then build proper guardrails and policies around the use of technology? So those are the two angles that I usually think about when, generally not just AI, but overall any disruptive technology that sort of comes to light.
And I do agree with that, of course. I didn't know that story specifically about the Court of was it the Court of Appeal that was.
No, it wasn't Court of Appeal. It was Superior Court of Ontario.
Superior Court. I'd heard something similar, of course, an earlier one out of BC. But it's one of these things. AI is a fantastic starting point at the moment, as Yashar says. It's not a terribly good ending point. And we've all heard the cliche, the human in the loop or the human in the middle, whatever it happens to be. And that's the thing. We're professionals. We're paid as professionals. And if you're in the legal field, you have an obligation to your client to verify the work in the same way that you would verify the work of a law clerk. I mean, the idea. So, I think we're all on the same page here. It was reckless of that lawyer or that firm to use AI as the finishing point and not verifying the references. And also to Yashar's point too, perfection somehow has become the standard, as though because we've used Gen AI, it has to be perfect now, or if it isn't perfect, I'm not interested. One of the dangers of a story like that, and it's important to tell that story, is that it sends the message, oh, you shouldn't use it, like you said. It's a cautionary tale. No one ever said we're replacing all lawyers all the time for every bit of legal work with AI because it's so perfect. No one has ever said that. And yet that's unfortunately how people are sometimes behaving. So the good news is, I guess, we got a job. The good news is we need lawyers and we need clever people to review, if nothing else, just as you would, as I say, a law clerk or an associate. That's the technology. It's a fantastic, though, starting point. And I guess as long as we keep that in mind, know the limitations, just like any other tool, right? You don't use a hammer to saw a piece of wood, then you're fine.
Yeah, look, obviously it sounds like the three of us are on the same page, which is not surprising. And I mean, what I've always said, which is pretty well the same thing you're saying, is I treat AI like an associate or like a clerk. They're going to do the work. They're going to do a pretty good job, at least for a first pass. But I'm going to review it and make sure that it is as it should be before it's submitted to a client, a court, or anybody else. So I guess the question, and we can broaden this beyond the legal profession to any workplace that we're talking about. And I guess part of the challenge is, most people, when they think of generative AI, they know of ChatGPT, they might know of Google Gemini and Microsoft Copilot, some of the most common ones, but there are, I think, probably hundreds. Someone told me about a website called There's an AI for That. And I went on to it the other day, and I think there are probably more than hundreds of different AI solutions. So as a business owner, a manager, what would you guys suggest that we put in place to control, I guess, how people are using AI? And I know it's a pretty broad statement, so you can take it any way you want, but there's got to be some sort of policies in place. Kent, do you want to go first on that one?
Thank you.
You guys are both far too polite, so I'll call names out.
We need the help. So true. And I've used that site as well, and just been stunned by the array. And like most of us, we get hit with newsletters and things like that. A new tool, a new offering, even just new features in the tools we already know, and that's impressive. And that would be enough, right, to kind of get your head around. This takes really sober, small C conservative managerial acumen. You need, whether you're a solopreneur, whether you're a law firm or a principal at a law firm, you have to sit down and decide what your policy is going to be, because there will be data leakage, there will be improper use. People, and even with a sincere worker who's trying to do the job as well as they possibly can, and they see AI as a great assistant for them, but they're sharing too much information with the AI. They're not putting in the proper security around whether that data is used for training later, all that kind of stuff. So you sit down. What you'll find too, though, in my view, is it pays huge dividends, because you find out that something like Perplexity might do a fantastic job for a certain kind of job. Yashar has a tool that was going to be good for contract comparison and that sort of thing. So as these people right now feels like this way too general, way too broad technology, which it is. But the thing is, then we're going to see these fantastically smart people create these bespoke tools that will work for your particular case. It will, however, be, this is kind of exciting though too, a never-ending journey, right? So the thing is, just because you found out that Perplexity does a good job, the search isn't over. I mean, the search is over today. These new tools and new offerings will continue to mutate, and we have to see that. I wonder whether, and I'll throw this out to Yashar, like, will this be a case of like Coca-Cola? Like, where there's Coca-Cola, there's Pepsi, and then there's everyone else. Like, is that what the natural monopolistic forces, is that what's economic forces, is that what's going to happen? Or will we still see what we have now, which is this wonderful age of kind of like bench scale AI projects that are super cool, made by very small teams who are finding very, very thin vertical markets that they can exploit. That's also pretty cool too.
Kent, I agree with you. Around the policies, I think I build on what you explained in your example on Perplexity around experimentation when it comes to firms trying to adopt new technologies such as AI. I think if you are adopting any technology, not just AI, you want to make sure that you understand how it works. You want to understand its limitations, its capabilities. And there are three very specific policies that, in my view, are very important. It used to be just the two at least, but now we're adding the third one. It used to be InfoSec or information security policy, the data policy, which sort of governs how you manage your data asset in your enterprise or organization. And now with the complexity of AI, you do need to have an AI policy, which is informed by those two other policies that you have. Exactly what you said. What documents are we allowed to interact with AI in our organization? Is it safe to, for instance, upload hundreds of pages of privileged information, client information into the tool? And what happens if there's a cyber breach? What happens if those information leaks to dark web, or if they get hacked, or etc.? That's a huge reputational, financial, and regulatory risk. So I think at the end of the day, in my view, it comes down to how well are we managing the risk of adopting AI. I think there's no question around, at least not anymore, around at least maybe the promise of the productivity. Maybe not everything is there just yet because of where technology is at, but how are we managing our risks? I think that's the most important question that, in my view, every business owner, especially a law firm, really the CEO or the CIO or the managing partner, they must be asking themselves, how are we managing the risk of the technology adoption?
So the faceless producer's voice is going to jump in here right now. The reason so is that you're touched on something that we're experiencing in my company with lawyerlocate.ca and LegalTube, is we're developing our own AI for legal marketing strictly. And you talked about, Kent, the narrow verticals. This is exactly what we're doing for a solely Canadian legal marketing. It's being built for sole practitioners and small boutique firms, which is basically where most of law is going in Canada. But one of the interesting things that talks to what you gentlemen are bringing up is that in working with the developer hand to hand, one of our keys was, well, twofold. One was he educated us very quickly on garbage in, garbage out. So the trick that we've learned already that most people don't seem to get their head around is the key to the success with any AI is the prompt. If you're not spending the time to prompt properly, you're going to get terrible results. That's just simply as that. But in our AI development, what we've looked at is we had to ensure that every step of everything they were doing, whether it was developing ad campaigns, or that there had to be a human checkpoint that said, okay, yes, you can proceed. So literally every step, and we have like multiple layers to developing a marketing plan with this AI for individual lawyers or law firms. Every step has a pause where there has to be a human interaction to approve that stage, and then it goes forward from there.
Yeah, I think that's sort of the risk mitigation and taking a risk lens approach to make sure that we are sort of putting all the checks and balances as we are developing or implementing or deploying a new technology such as AI. And Mark, it's interesting that you say that. I see that quite a lot with law firms who are adopting AI. And what I'm particularly seeing in terms of policy, writing up the policy, but also enforcing the policies, are that they now in their AI policy, one of the points is to specifically set timelines, like a weekly cadence where people who are using the AI, let's say to draft documents or to create summarizations, to document what prompts they're using, to also document what are the things that they're seeing AI is doing well, and what are the things that they're seeing AI is not doing well. And now furthermore, they're engaging with the vendors, sort of like a dyadic feedback loop to tell the vendors, what is it that your tool is doing well and not doing well. So that's refinement process I'm seeing many law firms are now adopting, especially in their AI policies.
It's a great concept. Yeah, I know another firm that is similar to us. They're very tech savvy, and I think at least weekly they're getting together and just going around the table talking about what have you used AI for this week, and talking about what worked, what didn't work, just like you're saying, Yashar. Because we're all trying to figure this out. So I think that's a really important point. Kent, I think you were going to add to that.
I was just saying, thank you. I was just thinking that that's such a clever way we were talking earlier about, the trust building, the confidence in the product, and what a great way to share that information within the firm. And it strikes me too, it's sort of like, feels reckless not to do that. Can you imagine if you said to a client, oh, wow, we're pretty sure it's good, but we didn't actually verify. We relied on, say, the warranties of a third party about how good it was. I'm not saying people do that or would do that, but I mean, to be able to go back to the client and say, no, we vet this every week and we look at the pluses and minuses and we learn as we go. I think that's got to be a very powerful thing to be able to say to any client anytime.
Yeah, I like that. And also just like we're all figuring this out. And I guess that's part of the problem. I don't think, my firm will be any different. I might be doing things one way. Other people are doing things a completely different way with different tools, different prompts. So yeah, I think it's really important to try to systematize that and figure out the best way to do it, frankly. And I wanted to come up back to something that Yashar, you talked about, which is the privacy concerns or data leakage concerns, which I think is probably one of the biggest concerns that people talk about. And a lot of people have this view or this understanding is for the large language model that if I upload a contract, let's say I draft a contract for IBM. If I upload that and have it refine it, it then gets, it learns from that, and some other employment lawyer tomorrow might say, give me an employment contract, and they will get that contract that I drafted with the parties' names in and everything else. So I'd be curious to know your thoughts on how likely that type of thing is, but then also, what people should be doing to avoid that type of situation. Yeah, so go first on that one?
Yeah, for sure. I think it's a question that I personally get asked quite a lot from the law firms who want to adopt AI. I'd say when AI came around about maybe 2.5 years ago, that was not fair. I mean, part of the problem with just the AI software development lifecycle is that there's minimum amount of testing that's done. It's not like your mobile application that you're banking with CIBC. It goes through a very rigorous testing and quality assurance. AI applications generally aren't like that because everybody's in such a rush to build and put something out to the market. It's almost like fear of falling behind. So oftentimes they cut corners when it comes to testing. This was the case some time ago when big firms like OpenAI came, and you've all heard about the Samsung engineers who put sensitive information and it got into the public and they got them fired, etc. I'd say as of early 2025, most of those AI data privacy and cybersecurity privacy issues are largely addressed by reputable organizations. Now, I say this, I need to also be careful because if you're only using, for instance, a large language model like ChatGPT, you need to make sure that you read their data privacy policy. Every organization is different. Mostly now, based on my understanding, they anonymize your information. Like if there are PII or private information, identifiable information, first name, last name, health SIN number, etc., they take those out. They replace them with some random generated numbers that they use the content of your document and then feed them back into their training. Sometimes if you have an enterprise license, etc., you may be able to opt out, but that's generally what happens. With the specific tools, you will have better options in terms of completely opting out. The risk is still there. The problem with that is that if you're only using a tool to upload, I don't know, one document, a 2-page every month, the risk score is a lot lower when you're dealing with uploading hundreds of pages of private information to an AI tool. So you see that the risk score goes up significantly. So it comes down to how much risk are you willing to take, and what are the privacy policy and information security policies of the vendors. The other aspect is not the vendors, it's you, it's the organization who's adopting the technology, because it's a two-way street. For instance, are you using a multi-factor authentication in your systems? Have you put the proper data leak prevention policies in place? Are you, for instance, anonymizing those IBM contracts, as an example, before uploading them to the tool? So there are a lot of considerations that needs to be discussed, have dialogued on, and properly, have a checklist to go through for an organization to say it's now safe for us to use the tool.
Yeah. We're finding the same thing. We're a Microsoft company. That's just who we've partnered with, and we rely heavily on their warranties, and Adobe as well, their warranties, and as well publishing just what we talked about. Everyone in the organization is supposed to know this very heavily published, very heavily spoken about privacy policy and AI policy, and making sure all the knobs and switches say don't share data, keep all that kind of stuff, and making it quite part of our, if you're an employee as well, part of the policy is you're not going to go rogue, and you're not going to go step outside and use an independent, I'm not going to use my personal email account to do corporate business, that kind of thing. That's also quite clear. That's kind of where we're at. We're price takers in that regard. I mean, we have a great ITS department, but we are relying heavily on the promises of third parties.
Yeah, and I think you hit the key on hit the key on the head. That's a new expression. We'll hit the nail on the head, which is people just going rogue, and it's often innocent, right? It's just, well, I want to use this tool and I can't do it with my corporate email address because it won't let me, so I'll just do it with my personal email address. But people often do that and don't really realize what the risks are. So yeah, having the policies, having the training is key. Like a lot of aspects of employment law, those are important. As we always say, the time flies by, so I'm mindful that we don't have a lot of time left. But one thing I did want to talk about, because this has come up a lot in the legal world and in other worlds, which is this idea that if you let people do AI, so if you let people have AI do everything for them, they're never going to learn how to do it. And then the example has been used in my firm is it's fine for me to have AI do the first pass at a contract review because I've done enough of them in my life, and I can then take the initial work and take it from there. But a first-year associate or an articling student who's never done contract reviews shouldn't let AI do it for the first pass. They should do it themselves. So how, as we move forward with AI becoming more and more prevalent, how do we make sure that people learn how to actually do these things for themselves?
Oof, well, that's a very, very hard question, and it's one that we grapple with, of course, as a teaching institution all the time. And I'm sure it's the same in corporate training and that kind of thing. Pardon me. Well, I suppose there is a model out there that says just because formal education works a certain way and has for 200 years, that's a very industrial model, the idea of having one lecturer and 40 students kind of thing and write a standardized test at the end of it. I mean, I'll speak again only for myself. I mean, I went to law school. I took a torts test. I passed the torts test. At the end of it all, I got the degree and everything. But that I certainly wasn't an expert on torts just because I went through a traditional process and to get that credential. And I'm not saying, I'm saying I'm leaving it there. I'm not saying it's good or bad, but I'm only pointing out we're married to a model, and that just may not be the only model. Well, we know for sure it's not the only way we learn. This is just a classic case. What we're talking about now, listeners could have figured out through other searches or used even AI to get this kind of a conversation happening. But there's something about the magic of a human conversation, the non-linear way we talk to each other, how we immediately follow up with questions. That very human process is how we ultimately learn, whether there's a formal exam or not. And funnily enough, law and medicine and accounting, the traditional professions, have a very good model about this. They say, we'll give you a little bit of, we'll start you out, we'll give you some basic knowledge. But frankly, I'm hoping you'll go to Stuart if you're an articling student in the law, and that you will learn the profession by watching the professionals do it. And that's a tried and true, and frankly, it's not very efficient, but it's an incredibly effective way to learn. So how
well, send them to me is clearly not very efficient. But
and certainly, this is the nice thing. The traditional model, very efficient. Is it effective? I'm going to say it's not so effective. And I think that's the trade-off we're going to have to make. But I'm comforted by the fact that it's actually a fantastic trade-off. I think I'd rather have an associate who's worked with you for 3 years and knows now a lot more about employment contracts than someone who took a long time, but they know more than the person who took that one employment law course at law school. And that's going to have to be what we do. We're just going to have to expand that because that's just how humans learn, and they will master it because they're with you learning from someone who knows what they're doing.
Right. I appreciate the plug. Yashar, do you want a final word on that one?
Just a final word. I think it's a problem that crosses industries, like software development. You could now a lot of AIs would write codes, and if you've just hired someone, out of college, are they going to use AI and come up with a SQL script or a C++ or C# program to do the work instead of, and everything is now remote, and nobody, a lot of people don't still go to the offices. So how do you put guardrails? I think it's going to be a process. It's a change process, and we're going to go through it. We're going to learn together. Interesting. My co-founder teaches at San Diego State University. She's a professor there, and we always have this debate with her about, how do we make sure that students don't rely heavily on AI? They do the work, and then yes, they could use the AI to maybe improve their work. And I'm now hearing about programs coming to market that would detect if you've used, for instance, ChatGPT to do your document review or to write your summarization. And so I think we're going to see a big process and a big change. A lot of innovative solutions are going to come, which is more geared towards penalizing. But I think at the same time, we need to make sure that we continue to talk about it, have the dialogue conversation. And I think it's going to start at the education and educational institutions to sort of create that foundation.
Makes sense. And I know I said we were going to wrap up, but Kent, you looked like you had a thought and something you wanted to add to that.
Oh, I appreciate that. It's related. It's the converse question, I suppose. But what do we do with when we talk about mastery of a topic and subject matter experts? When something like medical AI apparently can outperform humans, the best human available, and it can say, it can detect horrible disease X with much greater effectiveness, much greater accuracy than someone else. And then the question is, well, what's the role of the expert in something like that? That was not the question that you posed, but I point out there when it comes to something like human mastery, are we chasing a chimera? Is it a phantom that we can never reach as AI progresses? It's something something that vexes me.
I love the fact that even though you're not a practicing lawyer, you have mastered the art of answering the question you want to, as opposed to answering the question you were asked. So we will wrap it up there. But again, Yashar and Ken, thank you both for doing this. And before I take my turn to fire away, if people did want to get in touch with you, how can they find you? Kent, do you want to go first?
Sure. I'm at Seneca, Kent.Peel at senecapolytechnic.ca. And I'm on LinkedIn too. If you just search for Kent Peel, you'll find me.
I'm going to say the same thing, except the numbers are different, the alphabets are different. You can reach me out at Yashar at Kolabrya.com. I'm also on LinkedIn, Yashar Daf. That's my LinkedIn. Thank you.
Perfect. All right, I will now take my turn to fire away. So here's my question. In the world of employment law, why are we still pretending like arbitration doesn't even exist? Many of you have probably seen the headlines talking about how in Ontario they're looking to completely overhaul our system of civil litigation with the goal, not surprisingly, of reducing the time it takes to get to trial. Will it work? Maybe, maybe not. But here's the real problem. Our civil justice system is a one-size-fits-all system. Whether you're litigating a multi-million or billion-dollar commercial litigation or a simple wrongful dismissal claim, it's the same process. And right now that process is slow, inefficient, expensive, and unpredictable. But here's the interesting thing that we often forget about. You're not stuck with it. You don't have to go to court. You don't have to wait for the governments to fix the court system. You can design your own process, your own system by using arbitration. Even better, build it right into your employment contract, so there's no need to negotiate it later. There will be a requirement that every dispute go before an arbitrator and not before the courts. So why does this make sense? Arbitration is faster. It's more efficient. It's also fully customizable, as I have said, and it's far more predictable. So what do I mean by all that? Well, first of all, in terms of timing, you set the schedule. No more waiting months to get a court date. And when you finally get that court date, you don't have to deal with a judge who shows up late, interruptions, ending early, etc. You decide when the hearing is going to take place. You set the timetable for the whole litigation process. And when you get to court or arbitration, the time is used productively. You start on time, you end on time, and you get things done during the day because the judge is not worried about 17 other matters. Arbitration is also fully confidential, so no airing of sensitive, dirty laundry, no talking about things you don't want the public to know about, and no risk of a damaging precedent. So, for example, you're worried that a court's going to say you've got to give all of your dismissed employees post-termination bonuses. Go to arbitration. It's private. There's no precedent. It's also fully customizable. You get to decide for each case how it's going to work. Is it going to be in person, written, Zoom, hybrid, how the evidence is going to be introduced into the hearing, whether there will be examinations for discovery, whether it's in person or written, whether there's a right of appeal. You get to decide that in each case. For really simple cases, consider final offer selection or baseball arbitration, as we call it. Quick, decisive, and it's done. The other great thing about arbitration, you pick the judge. No more worrying about whether your assigned judge is going to be somebody who understands the nuances of the case you're dealing with. You pick someone with the expertise to handle your case properly and effectively. So bottom line is this. Just because you've always gone to court doesn't mean it's still the best option. If you're counsel, you should be considering arbitration and proposing it where it's appropriate. If you're a party to litigation, ask your lawyer whether they have thought about arbitration. And if you're drafting contracts, build it right into the contract that arbitration is the only way disputes are going to be dealt with. Bottom line is that in 2025, if you are still automatically going to court for every wrongful dismissal case, you're really missing an opportunity. That's all for today. And that's a wrap for episode 88 of Fire Away. So I appreciate you guys for tuning in. I would love it if you'd let us know what you think in the comments. If you enjoyed the episode, please hit subscribe, share it with your colleagues and your friends. I guess if you didn't enjoy it, you can share it with people you don't like. But one way or the other, please do share it. If you can catch new episodes every third Tuesday of the month, wherever you find your podcasts. You can follow Rudner Law on social media to keep up with Canadian employment laws and updates. And lastly, but not least, thanks again to Yashar Daf and Kent Peel for being guests on this episode. Thanks to Mark and LegalTube.ca for the work behind the scenes and over the speaker. And to quote one of my favorite hockey broadcasters, the pleasure was all ours.
People to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.